Sir, shall we start? Hello, sir.
Hello. Hello.
Sir, shall we start? Hello, sir. Shall we start?
Voice breaking. Hello.
Hello, sir. Are you able to hear us properly?
Hello.
इसमें भी क्यों नहीं आ रहा है? तेरे ईयरफोन लगा रहे हैं?
बात नहीं उससे नहीं होगा. बोल तो बोल. बात कर.
Hello. Advait, are you hearing us? Advait?
I can hear you, sir. Screen is stuck.
But we can hear you.
Why sir is facing problem? I don't know. Prabhat sir, I think everybody is able to hear. I think you are only the not able to hear. Hello.
Is he still here?
Yeah, sir is here. I don't know.
Which one is this?
I think sir left. Did you?
चेक करके बोलना करो.
वही चेक करना.
Dude, sir is still connected.
Sir is there?
Yeah.
Let me see. I'm not able to see him.
M. Look at M.
M.
Yes. माइक एंड माइक्रोफोन बोलना.
हम चालू कर सकते हैं उसका डायरेक्टली.
नहीं. तू कौन सा भी कॉल करके बोल रहा है.
Hello, sir. Sir, you are facing any problem? I think, sir, everybody is able to hear us. I think you are the only one who is not able to hear us. So maybe problem is in your side. Yeah. Can you connect to somebody else's phone? Because whenever I try to call you, it automatically gets disconnected. Maybe your network is weak. You're connecting to a phone or your laptop? You are still in the meeting because we are not seeing you.
He is in the meeting.
I think your microphone is off. Can you just? No, we are not able to hearing you through meeting. Your microphone is on off.
Hello.
Yeah. Now voice is coming. Okay. I will start. Hello, sir. Hello.
Parth, his mic and video are off.
I told him that your sir's microphone is off. Sir, your microphone is off. Can you just click on so that we can hear you? Hello, sir.
और भी प्लेटफॉर्म है जूम से उन्होंने किया कनेक्ट
उनका नेटवर्क प्रॉब्लम है. प्रॉब्लम ये है. कनेक्ट तो हो गए सर.
रिकनेक्ट करने के लिए बोल ना, डिस्कनेक्ट करके रिकनेक्ट करें.
पता नहीं हमको सुन पा रहे कि नहीं. लगी है सुरभि एक और है पौलवी है प्रबंध है अक्षरा है.
Can you hear me, Parth? Hello.
Yes, sir. Yes, sir. Are you able to hear us now? Hello.
Hello.
Sir, you are able to hear us or not?
Hello.
Hello. Hello, sir.
Just a minute.
So we can hear you, sir.
I think he is not getting us.
Connection says lost. Oh, now he's gone also.
Ask him to connect with the sending.
He's there. He's there.
Yeah.
Isn't he? Oh, sorry. He isn't. Lavan, show us your face, bro. Nice haircut. A nice shave also.
Really nice haircut, Prabhat.
Bro, is it visible? I off my video.
Now you off.
You just
Sit down
switched on and I saw a ray of hope.
Yeah, I offed it, bro. Thank you, bro.
देखो सर आपने कोई वीडियो
For 1 second.
हम लोग यूज
One more second you show us, please.
Once more, bro. 7.
अगर सर पार्ट
Hello.
Hello, sir.
Yeah. Can you hear
Sir,
me?
you are able to hear us or not? Sir, are you hearing us?
Hello.
Sir, I am speaking. Are you able to hear or not?
Yeah, your voice is quite faint.
योर इज कमिंग यू स्टार्ट.
A minute.
Okay, sir, your voice is coming. So I will just give your introduction to our attendees and then you can start. As you all know, that Prabhat sir is from 2011 to 2014 batch. He did his engineering in electronics and communication engineering. Then he joined Iyer and Dhulia law firm in Chennai. Then he joined Singhania and Partners, and then he joined Chamber of Vivek Tanka, who is a Rajya Sabha member. Now he practices independently with a focus on arbitration. While working with Vivek Tanka, he has also assisted him in his various parliamentary duties. Sir has appeared in very landmark cases. I am sure Sir will deliberate upon it. Over to you, sir.
Hello.
Sir, you can start. Sir.
Yeah. Yeah. Thanks, Parth, for the kind introduction. Good morning to everyone, and I'm in fact very. It's a pleasure to be interact with you all, and I hope all are safe in these challenging times. So, as you all know, that I passed out in 2014, and later I joined litigation in Iron Dolia firm in Chennai, and then I moved to Delhi in 2015, and since then I've been practicing in Delhi. So I'll divide my talk into 3 or 4 parts, basically starting from sharing my experiences as to what all I learned. I mean, generally there's a basic confusion among the students as to whether to join a law firm or a lawyer or a senior advocate. And unfortunately, I have tried all of these options. I have worked for a firm, I have worked for independent advocates, and as well as I have worked for senior in the chambers of senior advocate. So I'll briefly touch upon it, and then I'll also tell you basically what is arbitration. I'll just touch upon briefly because there is misconception and among students and they confuse it with mediation or conciliation. So I'll just briefly tell you about what is arbitration, what kinds of arbitration are there, different types of arbitration, and then the sectoral specifics, which is not talked about generally. Hello, am I audible?
Yes, sir.
Right? Hello.
Yes, sir. Absolutely audible.
Yeah. So basically, in a lawyer's chambers, as a lawyer, you'll be paid only if you are useful. Okay. So in what ways can you improve upon your skills, and in what ways you can improve upon your knowledge set? That is important. So 3 or 4 important skills that are required to succeed in this profession are, I mean, drafting skills, research, speaking skills, as well as, I mean, court craft. So now, in terms of cross-examination is another art which is dying. I mean, in these days, not many people are aware with the intricacies of the cross-examination. So in terms of drafting skills and research, these form the core part of your preparation of a brief or as a lawyer. These skills are most important. So you see, court craft, it comes with time. You cannot learn it overnight. And you have to observe senior advocates in courts and other counsels who have been practicing for a long time and have developed it over the course of time. So you would have to learn it over a course of time. Whereas drafting and as well as research, you can, in the initial years of your career, you can improve upon these skills. So in terms of opportunities that you can get of learning these skills, I mean, initially it would be suggestible to all of you, I mean, if you are interested in litigation and arbitration, that you can join in a litigation firm. Depends on your financial liabilities as well as your appetite for risk. And if you are not fortunate to get into a firm, you can join any advocate who is of above 5 years of experience, because those kind of advocates who are in the mid-range, between 5 years and 10 years of experience, they might not pay you much, but the kind of experience that they will give you would be far, far more than what you get in litigation firms or chambers of senior advocates. Because these advocates, they are in the initial stages of their career, they have enough work to give to you, but they might not have that much money because they are themselves growing and they're growing phases. So, and they need you. These advocates, they rely upon you in mid-range experience of mid-range advocates, they rely upon you because they rely upon your research, they rely upon your drafting because they need help. So in these places, you can learn very much. I mean, I cannot explain and tell it to you how much you can learn, because the kind of experience that these chambers provide, it's unparalleled. And because in litigation firms, now in terms of litigation firms, I'd like to tell you that in litigation firms, the work happens in silos. I mean, your job description and your job profile is described previous, it's set. An associate does a particular kind of job, a senior associate, a draft is, associates mostly do research work. Then the senior associates mostly get to draft few applications. The major chunk of work and drafting is done by principal associates, and the partners themselves, they don't argue. The partners brief then to the senior counsels or the independent counsels practicing outside. So what you want to do, that vision has to be clear from the very beginning. I mean, you can, it should be very clear to you whether you want to become a briefing counsel, whether your skill sets are more good, you are very good in speaking and you can think, and as well as an application of law, and you can think on feet. So in that, and you want to become an arguing counsel. So depends on what is your vision and what you want to do in life. That in these times, especially in law school, take as much time as you want, explore as much areas and fields of interest you have, and zero down to, if not one, at least few options as to what you want to do after college. See, like suppose I did internships, I was quite in a dilemma between either a corporate job or litigation. I did all my internships in non-IP. I did not do any internships in intellectual property. From the beginning, I was sure that I want to enter the field of either litigation or corporate mergers and acquisitions. So I interned with Desai Devanji, Indus Law, J. Sagar Associates, and more or less, I enjoyed litigation much more than what I did for corporate. So after, and there were very few job opportunities that came in our way during our time for corporate in our college, because our college is mostly famous for intellectual property. So then, but I tried my hand at litigation and I enjoyed it. Within the very first week, I thought that this is what I want to do all my life. And I dedicated myself solely in that direction. So basically that is very important, because because there is a lot of dejection that might come your way, or you might feel dejected while working in the initial years. There might be a lot of disillusionment. So at that point of time, that clarity of thought is very important as to what you want to do. Especially in litigation, if you are, chicken-hearted, you might not survive for long. This is a very tough profession and it takes a toll. The hours are long, and especially the results are also you cannot see quick results. It will take time. So if you are in for the long haul, then this profession definitely rewards you, but it takes time, and that patience you have to have. So then in law firms, that's what I wanted to tell you, that in the law firms, the work is, it works in silos. You cannot, if an associate wants to argue, he might not get to argue. Even if an associate wants to draft much, he won't get to draft. So during that point of time, I tried to develop my writing skills. I used to write for journals. I used to write for blogs, and the firm also has, all the firms these days have business development practice, where they have arrangements with websites and blogs like Bar and Bench, Mondac, etc. So where you can try improving your writing skills and publish as much as you can. In fact, I'll recommend you to try to learn these writing skills, writing of articles and research papers in your college days itself, and try to publish as much papers as you can, because these skills are very important in litigation, and especially if you are not from of a legal background. I was not. I am a first generation lawyer, and my 3-4 generations on paternal side as well as maternal side. So writing is the only way where we can market ourselves as to how good we are or how well we understand law. So try to read as much as possible. Try to write as much as possible during college days. I'm not saying do not enjoy your college time. I mean, that's also very important. Just try to maintain a balance and just find some time to at least read one case law per day. I mean, I cannot emphasize much more than this, but it's reading abstract, I mean, law from commentaries. It's better to read one case law completely. The case law, because it shows that it goes in a flow from facts to analysis to submissions of the counsels, and the analysis, it shows you, you go into the mind of the judge, how you proceed to decide a case. And you learn much more by reading one judgment than you go read by 20, 30 pages in a commentary. So commentaries, you can look only if you have some doubt of regarding certain terms, regarding certain issues, you can look for commentaries, but try to read case laws, and that will help you very much. Now, in due course, I'll again come back to this topic as to what you'll learn with seniors, with advocates, with firms. I'll just briefly tell you about what you learn at senior advocates places. Many people, counsels like Mr. Kapil Sibbal, as well as other senior counsels, Abhishek Manu Singhvi, Harish Salve. These senior counsels, it's tough to get in their chambers, but there are many other senior counsels where you can grab an opportunity. At these places, generally, you don't get to learn drafting because the drafts are prepared by the firms, and these firms or lawyers, they come and brief these senior counsels. So more or less the draft is prepared, everything is prepared, even the points of argument are prepared by these counsels, and the senior counsels just give a touch up with their experience, and they will finally, using their court craft, they will put the matter in such a way which is appealable to the judge. So at these places, what you can learn is how you should read a brief. At a senior counsel's place, I mean, you generally, the job description would be related to preparation of list of dates or any research points that is missed by the counsels or the firms. You can add to it and you can research, and mostly it would be appellate work. I mean, there won't be any drafting work or examination or cross-examination work, nothing. It would be, the brief would be ready and prepared. In fact, in the very first year, I went to Mr. Arvind Dattar after completion of law school, and this is what he told me, that you won't learn anything with me. The briefs come prepared. I read them, I argue. I mean, hardly you'll just be observing me, which won't help you at this stage of your career. So he suggested me it's better to learn at a lawyer who is younger and who has drafting and research work. So now I'll just briefly touch upon what is arbitration, because I'm told that this arbitration as a career option is, I mean, not many people from our college have been in this area and field of work. So arbitration is basically, I mean, it's neither conciliation nor mediation. Mediation, conciliation are more like settlement talks, and a mediator helps the parties to arrive at a compromise. Similarly, conciliation, whereas arbitration is, in simple layman terms, it's litigation in a private forum. The rules of procedure change. In litigation, the rules of procedure are governed by the Civil Procedure Code, whereas in an arbitration, the party autonomy allows the parties to frame the rules, or in fact, to choose particular rules as to how they want their conduct of proceedings to be governed. So now in Arbitration Act, arbitration are two types: institutional arbitration, ad hoc arbitration. Now, institutional arbitration, ad hoc arbitration is basically you just agree in your contract that we will resolve our disputes through arbitration. And the Arbitration Act 1996 would govern our resolution of dispute. And you choose a particular seat or a place of arbitration. And the Arbitration Act consists of the rules of the conduct of the arbitration, as well as the other procedural provisions which are the court, which are related to the supervisory role of the court, which supervises the arbitration. So once you read, I mean, I'm not sure all of the students must have been thorough with the Arbitration Act, But once you go through chapter 3 to 5 of the Arbitration Act, basically contains of provisions of conduct of proceedings. So like how a plaint has to be submitted. Plaint is termed as statement of claim in an arbitration. Then how a written statement is called a statement of defense. So how a statement of defense is to be filed and within how much time. These are all dependent on the parties. Whatever the parties may consent, that would be the binding factor on the arbitrator. Plus, as well as you can choose your judge. In a court, you cannot choose your judge, whether he has the technical expertise to decide this particular dispute. Whereas in an arbitration, the parties may consent for an arbitrator or a judge who has these technical qualifications or who understands these technical aspects. So now this is ad hoc arbitration, where you don't choose the rules of the conduct of the arbitration. They are governed, then by default, the Arbitration Act prevails, and by default, the Arbitration Act provides certain provisions for conduct of proceedings. You are governed by that. Then there is institutional arbitration. In India, institutional arbitration is very less. It's not prevalent. Whereas in Singapore and London, institutional arbitrations is highly recommended and it is highly used by the parties. In institutional arbitration, you go to arbitration in a particular institute. For suppose there is a center called the Nani Palkewala Arbitration Center or an International Commercial Arbitration Center in Delhi, ICA. So now you go there, you submit to the rules in your agreement and contract. You decide that the conduct of proceedings shall be as per the institutional rules of ICA or ICC Paris or SIAC, that is Singapore International Arbitration Center rules. So the conduct of the proceedings shall be as per the institution. That institution would devise certain rules for governing the procedure of the arbitration, and you choose that rules directly. It's a ready-made, tailor-made rules, and you choose them. These are institutional arbitrations. Institutional arbitrations are not much prevalent in India, but the government is focusing on it, and the 2019 amendment specifically focuses upon, making India a hub of international arbitration and focusing on these institutional arbitration per se. So now the sectors of arbitration. Now, see, like suppose I practice in mostly construction and infrastructure arbitrations and as well as commercial arbitrations. Now, the arbitration is just a procedure. This has to be very clear in mind. It is a procedure to resolve a dispute. It's not a substantive law or something. Contract Act, Sales of Goods Act, these are substantive laws which give rights and liabilities to a party depending upon a transaction. Arbitration Act is a procedure like Civil Procedure Code. In Civil Procedure Code, it's for courts. Arbitration is for arbitrations. Arbitration arbitration proceedings. So now you have to specialize in particular, because it's a vast area. I mean, as it is a procedure, it is applied to each and every commercial dispute. More than 70% of commercial disputes are resolved through arbitration. In fact, there is a report of ICC Paris that it says that more than 50% of the disputes globally resolved through arbitration are construction arbitrations. Now, why you choose arbitration? That's what the benefits of arbitration are. You get to choose your judge, you get to choose your rules, and you can resolve technical disputes quickly. You don't have to wait for the court roster for your matters to come up. The dates are already fixed, and you get to prepare. You get a specific timeline is there in between which the dispute has to be resolved. Now, after the 2015 Amendment in Arbitration Act, the Indian arbitration also has a specific time limit that each and every arbitration has to be finished within 1 year, with extension of 6 months by the tribunal and then later by the court, as and when the need arises. So these arbitration is a time-bound procedure and time-bound where you get a time-bound relief. So that's why commercial parties, they obviously always would prefer arbitration, and in future this would be the go-to thing. Litigation would reduce significantly, as you can see that all the litigations is now getting distributed among the tribunals. Like suppose the Insolvency and Bankruptcy Act, there is a tribunal, NCLT, National Company Law Tribunal. Then for telecom disputes, there is TD-SAT. So in future, mostly except criminal and civil matters of property matters, or matrimonial matters, most of the matters would now go to these specialized tribunals or arbitration. So now arbitrations are of different types. I mean, for different sectors, there are shipping contracts, there are commercial contracts, like there is oil and gas exploration contracts, like in the KG Basin, you explore oil. Reliance, suppose for example, a company like Reliance has many contracts with the government of India regarding exploration of oil in KG Basin. So now it's a highly technical dispute, extremely complexities are involved, which requires people with technical expertise. And there, I mean, as we mostly from RG, we are all technical students and we have a technical background. We would be in high demand in future, because these disputes, most of them are non-lawyers. It takes extreme, I mean, the engineers have to take a lot of pains to explain the technical aspects of a case. For instance, I do construction disputes, construction and mechanical construction, as well as civil construction disputes. Now, oil and gas projects, all these projects are huge projects, minimum of 200 crores, 300 crores. The claim values are huge. Now, in these, I might have to understand what is a scaffolding in a mechanical construction contract where I have to lay pipelines, oil gas pipelines. I'm the contractor. The IOCL or BPCL or HPCL, these PSUs give contracts to individual contractors to build pipelines. Now, to build gas pipelines, there are many things. You have to understand how a pipeline is constructed, what all goes through, what preparations the contractor has to make, what is the scope of the work of the contract, and then apply these provisions of law, Contract Act, Sales of Goods Act, etc., to the specific facts of the case. Now, for this, I would have to understand what is fabrication. These are all technical terms: fabrication, scaffoldings, how to lay down the pipes. So these technical aspects, the more you know the technical aspects, the more you will be paid. See, pay as I said, you will be only paid if you are useful. The more useful you are and the rare the knowledge is, you will be paid more. That is the thumb rule of the market. You won't be paid for things which everybody knows or which is available, on a phone call. You won't be paid for those skills. So as law students, I would tell you that during this time, first of all, you have to think, you have to be very clear in your mind as to what you want to do. And then if you are interested in arbitration or litigation, because they are interlinked, once arbitration is challenged in courts, so it's both. The skills are mostly similar that are used in both the cases. So I would suggest you to at least master, if you are interested in arbitration, at least master. Now it's time of specialized arbitration. It's not about just that you know arbitration, you can do all kinds of disputes. No, you have to be a master of one sector. Like suppose I'll just number a few sectors: shipping, dredging, infrastructure arbitrations, then e-commerce, mercantile law, defense arbitrations, telecom arbitrations. So defense projects, like suppose defense projects are deal like any purchase of guns or modulars or helicopters from a particular country, there would definitely be an arbitration clause in that contract. And if there is a dispute as to the failure of obligations by any of the parties, the dispute would be resolved through an arbitration. Whether you see the Antrix Devas deal or the other, even the Rafale projects of whatever, which is very common in the public knowledge, public domain, these contracts do have arbitration clauses. And if there is any dispute, the government of India would get into an arbitration and resolve these disputes with them. So specialize one sector and read as much as you can about this sector, understand as much as of the technical aspects, not the law part, as well as the technical aspects. As much as you learn, you will be more useful for the fraternity, and definitely the client would come to you. Now, I would just briefly tell you about how, now as during law school, you can spend that time, which my seniors used to tell me that you won't find that much time to read after you pass out. And unfortunately, it turned out to be true. and you don't get that much time to read, you try, I mean, that you definitely have to spend time for continuous self-development. But in college days, you can read as much as possible, and you can spread yourself and among all the statutes. I mean, it's basically logical application of the things that you have in your mind. What will among the various laws, how to interconnect the various dots among the various laws. That is what a lawyer does. So it's expected of you to read as much as possible and read statutes. I mean, understand statutes, learn interpretation of statutes. These are all very important and practical. I mean, these things would help you in the practical world. Your marks won't get you anywhere. Trust me. In real world, your marks don't count, and whatever standing you had in your class or in your college won't matter. It's only your content that you have. We are in a service-based industry. We'll be paid if we provide a good service. And you can provide a good service if you have the knowledge. We are basically a knowledge. I mean, this profession is basically dependent on knowledge. It's not based on how much it's what you know. It's about how much you know in a particular field. So I'll just touch upon how to study and how you can learn more and use those skills in the practical world. I mean, it's not much emphasized in college, during our days, as well as I don't know about in your, whether it is taught to you or not. But like you should know about a particular act in and out. You should read the standing committee reports, the bill, the law commission reports, as well as compare the bill and the act. Even a small missing word makes a lot of difference, and there are a lot of litigations regarding that. Then read a judgment, as I already said, read a judgment completely and read one case law per day. I think this much time you can spend for your career. I mean, you can enjoy as much as you want. And it is suggested also that you enjoy your time in the college. But read one case law, at least one case law you should read per day completely. And then be aware of the amendments, what are taking place in your field of interest or in the particular statute that you're interested to work upon. And follow articles, follow live law, follow bar and bench, and keep read because they continuously update. Daily, one judgment comes from the Delhi High Court or Bombay High Court. Follow at least these commercial courts. If you are interested in arbitration and litigation, follow these commercial courts, Supreme Court, Delhi High Court, and Bombay High Court, and just see the various judgments that they are passing each and every day. Then, as I said, master one procedural law, at least one procedural law. Arbitration, and if you are interested in arbitration and CPC both are indispensable. One or two substantive laws, that is the Contract Act and the Sales of Good Act. They are easier said than done. People spend their whole lives and they're still learning. Now, suppose, for example, how I recently got to know, I also during these times, I'm also attending lectures and podcasts. So where I have learned that there is a book by James Stephen, which is where you can note down his name, James Stephen. He was instrumental in drafting of the Indian Evidence Act and the Indian Contract Act. Now, as you know, these acts are the ones which have the least number of amendments. So you can imagine how well they were drafted when they were drafted, way back in 1862, 1872. And he tells you in that book each and every about what goes into mind as to what is relevancy, everything about what is the logic behind a particular provision. Now, these kind of books you can explore during college days because you have entire time in the world to look at these books and read these books. So that's what I want to emphasize is read as much as possible and go behind the act. Just wholesomely read. From the standing committee reports, you should know everything about, read a single provision. You won't believe that suppose in high courts, people specialize in injunctions, getting injunctions. They know everything about injunctions, from anti-suit injunctions, anti-arbitration injunctions, everything. So specialize in one thing, and if you are great at something, people will find you. There's a saying which says, if you are good, you will tell everyone. But if you are great, they'll tell you. So प्यासा पानी के पास पहुंच ही जाता है. if you are great at something, people will find you. Now, I'll just tell you about what you should, if you are interested in internships of arbitration, what you should focus upon, or in general, as to what should your be focus be in your CVs, or how should you go about finding opportunities. See, if you are targeting any particular firm or a particular lawyer, find out as to what he is or that firm is working upon. Find out the practice area of the firm in which you are willing to work. Not just don't run after money. Money will follow. If you are good at something, people will pay you. They don't have any option. See, basically, if you are great at something, they will have to pay you to get your services. So focus upon the process. The results will take care of themselves. The money is just a result. It's not the final aim. And you cannot think about money and get money. You will have to work to get money. So focus on in the initial years, I would suggest it's very easier said than done. People, when we were young and our seniors used to tell us, we also used to feel, nahi yaar, but no, I need this much amount. Without this, I cannot work. All these restrictions we place in our minds. There are fears, there are insecurities, and rise above these and have faith in yourself. Be good in what you do. Whatever little you know, be excellent in that, and you will be paid for it. So, in your CVs, that's what in your CVs you can actually highlight as to what is the practice area of the firm. Focus on those areas. Don't be honest. Don't put, too much there, because nobody is expecting rocket science from you as students. Everybody is expecting basics and fundamentals. As basic as, suppose I am telling you, people even after 10 years or 15 years in the profession don't know what is a ratio. They are not able to find a ratio disdendiae in a judgment, or what is sub silentio, what is a judgment which is sub silentio, what is per incuriam, what is obiter dicta. Definitions everybody knows, but application as to find what is the ratio in a particular judgment, that differentiates between a good lawyer and an average lawyer. So in your college, just focus on these fundamentals. Extremely important: how to read a judgment, finding out what is the ratio of the judgment, and you can challenge anything. In my experience, suppose I will tell you my experience, my first arbitration, which was a turning point in my career. It was a huge dispute, and all the contract was so one-sided against the PSUs. See, these PSUs, actually, they are using these contracts way back since 1950s, 1940s. So these contracts are highly lopsided. If you see the development of law, previously it was more a high-handed approach by these, and it was mostly the contractors were dependent on the largesse of the government. अगर मैं चाहता हूँ ये contractor काम करे, तो I'll pay him, I'll give him the contract. It was more of a charity by the government. It was not a right. Now, post-independence and now it's a fundamental right, and overall to carry on business. And slowly but surely, now it is based on market. So it's both the parties should be equivalent. The bargaining power should be equivalent. These concepts have come in. And law of equity in England also has been developed in this manner only. Initially, it was very lopsided. Then the Unfair Contracts Act came about there. And the judges also interpreted contracts as well as statutes in a manner so that the party which is and a weaker bargaining power is not coerced or under duress. It works, or pressed by the senior, by the what I call the dominant player in a transaction. So in that contract, every clause, each and every clause of the contract was against us, and there was nothing we could. The contract was so well drafted. Each and everything was in their favor. It was like, I promised to do a particular thing. I promised to do a particular obligation, but if I fail in my obligation, I'll not be liable. Now, what you do in such a case? You would have to go back to the drawing table and read you have to go back behind these contracts, how these contracts were evolved, how these contracts were interpreted in England, because most of our laws and our transactions, the common law is highly developed in England. So I went about reading Halsbury's Laws of England as well as English judgments. And then I got an idea as to what can be applied. And then I looked for Indian judgments and I found them. And so that's what. And all the judgments, you won't believe that all the judgments were against me. Supreme Court, High Court, uh, all judgments. Supreme Court, there are tons of judgments of Supreme Courts which were against us. Because basically the trend has been of literal interpretation of contract and rather an equitable interpretation. So then I went about reading about interpretation of contracts. See, basically the law is nothing but what to look for and where to look for. You have to learn these two skills to become a successful litigation lawyer or an arbitration lawyer. So then I came to know about interpretation of contracts as to I was curious about to know as whether how can one interpret these contracts in such a manner which is so unfair to one of the parties. This is a basic query that arose, and then I looked for interpretation of contract books, and I found various case laws in English law which have interpreted these contracts, saying that these are unfair terms or reading a particular clause in such a manner that the unfair becomes the fair. Okay, so these all skills you develop only because you know what to look for and where to look for. So that's why I'm stressing upon the fact that you should learn to read and act wholesomely. Read the standing committee reports, English judgments on the same topic. Just pick any topic, small topic like estoppel, Section 115 of the Evidence Act. It is so much useful. It's not much emphasized during the college days, but I'm telling you, it's so much useful in the real world where you can apply in each and every contractual transaction or a business transaction. Estoppel is applicable somewhere or the other. So if you don't know about estoppel, you won't think about applying estoppel in a particular contract. So in college, you can learn about the basics. What is the definition? And then it is basically connecting the dots while applying in a particular problem or a particular case. So that's all. I mean, I would like to, if you can ask questions, I would be happy to clarify and take as much questions as possible.
Hello. Hello.
Hello.
Sir, in interview you have mentioned that you have been part of so many landmark judgments. If you can touch upon that, like what is the
Yeah.
process, what is the challenges that we councils face in the ongoing litigation?
Yeah. So, like suppose one of the landmark judgments which I was part of, very fortunate to be part of, was the Aadhaar judgment. I mean, the 5-judge bench judgment recently passed in 2018 September. So in that case, I was assisting Mr. P. Chidambaram, and we were challenging the act. So we had to find judgments. Various issues, at least, I mean, there were at least 20 to 25 senior counsels with their respective teams who had divided one issue amongst themselves. And we were addressing one issue on the money bill. That money bill was being, the Aadhaar Act was being passed as a money bill. Now, basically, what is money bill is every act, every legislation passes first to the Lok Sabha and then to the Rajya Sabha. Rajya Sabha returns, and then Rajya Sabha gives its assent, and then it goes to the president for its assent, and it becomes an act. Now, in a money bill, it gives the government or the Lok Sabha the powers that it can bypass the Rajya Sabha in a manner where the Rajya Sabha does not have the opinion of the Rajya Sabha is not binding on the Lok Sabha in a money bill. The Rajya Sabha again gave its recommendations, and within 15 days, whether it is 15 days is given, and it has to be returned to the Lok Sabha. The bill has to be returned to the Lok Sabha. Rajya Sabha can make certain recommendations, but those recommendations are not binding. So, and the Lok Sabha, in effect or impliedly, can bypass Rajya Sabha in a money bill. So, a basic contention was in the Aadhaar bill did not have the ingredients of a money bill. However, it was passed as a money bill. So now for this, then the other stage is the speaker's decision is final as per the constitution, article 110, if I'm not mistaken. So the speaker's decision is final as to whether adjudication on the issue of whether it's a money bill or not. And if the speaker says that it's a money bill, then you have to oblige to that fact. So now we had to challenge that also. We had to attest to the fact, or we had to argue that the speaker's decision is also judicially reviewable. And the second portion was, when you come to the act and you see on the merits the various provisions, you will find that this act does not contain any provisions which fulfill the criteria of a money bill under 110. So there was no cases. The cases against us was already a 3-judge bench and a 5-judge bench judgment was against us, where it had held that the speaker's decision is final. Now we had to challenge those judgments as well. So now for that, I looked for Ireland. I was the counsel which was assisting Mr. P. Jadram. So all the drafting of the written submissions or the research or the strategy we used to propose to him, and then we used to discuss among ourselves. He used to direct us that you can look for this or that. So I looked for the constitutional debates, assembly debates. I read all the debates regarding money bill. There you get an idea. Then our constitutions are somewhere inspired by the Ireland constitution and the English constitution. So then I went about the English constitution and read the provisions there on the money bill, what's there. And in the English constitution, there was a specific term that it shall not be reviewed in any court whatsoever, the decision of the speaker, which was missing in the Indian constitution. The Indian constitution only said that it is final. It did not say that these are not reviewable in any court. So that's the major difference between the English constitution and the Indian constitution. So these are like this. Then we went about an exercise of all the provisions in the constitution where the word final or conclusive or not judicially reviewable were mentioned. And in all the cases, then we also read about the case laws about each and every provision where this has been held as not being conclusive, and a decision which is held to be final in the constitution is not to be final and it is judicially reviewed. So like these, I mean, there were various challenges. You constantly think about the matter while you are working on the matter, and you get the ideas more when you have all the facts in your mind and you keep thinking about it as to what can be done. Now, suppose then I suggested one another measure where we can say that the Raj Sabha, indirectly, nobody had that case law. There were other lawyers as well who were challenging this, who got prepared with this issue of money bill. But finally, Mr. P. Chidambaram only had argued all the matters. So I suggested another way of argument where Raj Sabha is basically part of the basic structure, because the Raj Sabha members are elected indirectly by the states, and they act as a check and balance on the directly elected people, the Lok Sabha. So in effect, you are bypassing one of the basic ingredients of the basic structure. So then in that direction, once you know the direction comes when you think about the matter, constantly think about the matter. When the direction comes, then you start looking for judgments or legal basis to substantiate that argument. So then we found judgments regarding saying that Raj Sabha does form part of the basic structure of the constitution, and we found judgments on that basis. So it was basically very extremely exhilarating experience, and it was extremely stimulating, where you discuss with Mr. P. Chidambaram daily, day in, day out, and you observe him as to, like, suppose I used to take constitutional bench judgments, 10 to 15 judgments, relevant judgments to him. But out of those, he used to pick only 1 or 2 important judgments. Now, what is important is these things you learn. All those 10, 15 judgments were important, but what he used to pick was what are the facts which are most similar or identical to the particular case. Basically, a ratio or a judgment is important only it decides on a particular facts. A judgment is delivered on a particular facts. So your case should be as similar in the facts with that case. Otherwise, the other party or the other counsel may distinguish the judgment, saying that this law is applicable on this facts, whereas in our case, the facts are different, and that's why that judgment is not applicable to us. So you have to take into account all these matters, and this was extreme. I mean, I was learning too much during this time. I learned a lot. How lawyers, the senior counsels with 40-50 years of experience in their experience, choose judgments. How do they read judgments? What effect they feel? Now, suppose another very important aspect what I would like to share with you all, that how important the councils should be responsible. Now, suppose Mr. Jaitley in his parliament speech used a term pith and substance of the act. He said that the Aadhaar Act is in pith and substance a money bill. Now, the pith and substance test is basically to distinguish between whether the law falls under the state list or the concurrent list or the central list. Now, that test cannot be applied in the case of money bill, because if you can find a bill in pith and substance, a money bill, then any bill can be passed as a money bill. You don't need a Rajya Sabha at all. You can put in pith and substance, you can put your the provisions which do not fall under the criteria of money bill, and then you choose one provision, you insert just one provision which is of money bill, and you say that in pith and substance this is the money bill. You can argue that also. So this argument we had prepared for these judgments, and we had our judgments to show that in pith and substance, Aadhaar Act was not a money bill. But Mr. P. Chidambaram, on the last moment, he said that he was of the idea that if we attest to this idea and if we fall into the trap of arguing pith and substance, whereas pith and substance should be applied only in the terms of the state list or central list, or in the legislations, should not be applied to find about a bill, because the test for finding a money bill or not is very clear in Article 110 itself. So you should not import something which is not there. And if today in a constitutional bench judgment, pith and substance test is used, in future, the governments, whatever government may come in the future, they might misuse this judgment and this provision and say that in pith and substance, a particular bill can be a money bill or not a money bill, and they can misuse it to their advantage. So there I learned how an advocates or counsels also have to be extremely, as a citizen, they have to be aware of what the dangers are of their arguments that may lead to dangers in future. So, I mean, the learning was impeccable during that time. I learned a lot as to what goes through a mind of a counsel, how he has to put a particular, and because I was also involved in the background, the preparation, you know what is to be argued and what not is to be argued. Because as a young counsel, you are exuberant and you are energetic, you want to argue everything, but that should not be the case. Basically, the judges are also humans, so you have to play to their minds as well. So yeah.
So
Yes.
this is sir, you have worked with Vivek Tankha, P. Chidambaram. You might have seen. Sir, you are able to hear?
Sorry. Yeah.
Yeah. So you have worked with Vivek Tankha, P. Chidambaram, or many other politician lawyers. So mostly they do their parliamentary work. They do their they argue in a Supreme Court. They do press conference. So how do they divide? How do they manage this much of load of work? Because you may have seen, you may have worked closely with them. So yeah.
So
Because they are
basically,
kind of a celebrity in their field.
yes. So this was also my, initial amazement. To my amazement, I also used to get amazed how they find that much energy to spend in all the areas of their life. So, and what I learned is, basically the top performers, or especially in litigation or in any profession, they are extremely involved in the work that they are doing at the particular moment. And the moment they shift their focus to the next job, they completely forget about it, and they are able to divert their attention completely 100% again to the next job. And this is how their 24 hours look like 100 hours, and our 24 hours are like 10 hours, because our time goes by and we are not able to know where did my days went off. But they are able to manage to do so many jobs in a particular day. They are able to attend press conferences. They are able to write books. They are able to write articles in newspapers. They are appearing in courts, constitutional bench judgments. They are appearing with 10 to 15 matters per day. They're also attending parliament at the same time. So closely watching them, what I learned is that when they shift their focus from one job to another, they are completely into the next job. They forget about it. Their mind works in, the silos. The parliament is at one place. The press conferences are at one place, and they compartmentalize their work and shift from one compartment to another seamlessly. They don't think about the other job while doing a particular job, and that's how I think you have to learn it over a period of time. And even I try to inculcate those habits, and that these are habits that have to be inculcated, and you have to work on it.
Good morning, sir. This is Utsav from first year. Uh,
Hello.
Sir, hello, sir. You can hear me?
Yeah, tell me.
Sir, basically, we are at the end of our first year. So basically, we have to choose what side of law that we want to practice in. And
Yeah.
arbitration we usually get in the final year, and that too, I think, in the last sem only. So, what
Yeah.
is your ideal advice? Ki how should we identify our interest in a certain law? What is the procedure to go about it?
Yeah. So, see, that's one of the, demerits. Recently in an email interview, also I mentioned this fact that in RG we don't get that much opportunity for internships to explore, because without doing, you cannot know what you actually want to do. So that's the, risk that we have to take. That's the call that we have to take within the 3 or 4 internships that we get. Now, basically, in our first internship, if you are after the first year, you can at least on the first internship you can take, and see, that's what, like many students, they want to get into jobs of IP councils or IP analysts in companies like ABB, Samsung, etc., TVS. So if that is clear from the beginning, no issues. But if you are sailing in 2 boats at the same time, and that is very natural. It's unfortunate, but yes, we have to make use of the whatever opportunities we have. So I would suggest the first internship that you do in the December first year, if you are in the first semester, that you can try at a individual lawyer, and you can learn some basics, observe court proceedings, take a feel of it. And then in the second internship, I would suggest you go for a litigation firm, or if you are interested in litigation and just want to learn, see what is litigation, how it goes about. So explore your first internship in litigation or arbitration in the first May, June, I suppose, after the first year. So then after that, if you are not sure, and if you are sure, you can give it another try, and then you keep on doing internships in a litigation firm or an arbitration firm. You can take help of seniors as well as professors to help you get into those firms. And but if you are, another thing I would like to tell you is, if you want to get into litigation, your internships, at the end of the day, won't help. It doesn't matter where you intern. Whereas, in only thing, if you're looking for a job at a particular litigation firm or the tier 1, tier 2 firms, they would ask you, and they would just judge you whether you have interned at a particular place and are you seriously interested in litigation or not. So they might ask you that whether you have interned. So at least have 1 to 2 internships in litigation firms. If you are doubtful about corporate and litigation, I'll tell you my experience. Like how initially I was very clear that I don't want to get pigeonholed in IP only. So from the very beginning, first internship, I spread out my internships between litigation and corporate. I tried both. The first internship was litigation. Then the second was a corporate, Desai Divanji. The third was Indus Law, again corporate. And the fourth one was J. Sagar Associates, which was corporate litigation or commercial litigation. So then in the final internship, my mind was more or less clear that this is what I want to do, that I was enjoying. And that awareness, see, nobody can take that decision for you or can explain it to you that you are good at this or you should do this. That interest has to come from you. And especially in litigation, if you're not interested and you just take it for the sake of it, for the money or for the, fantasize with the the life that it provides you. If it might not take, you might not go along with it. I mean, you will somehow, somewhere, you will quit. So it's very important to find your core area of interest, and that you can do only by internships. Spread out your internships. Try to balance out between having different experiences, as well as so that if any in later point of time in an interview it is asked from you that whether are you interested in a particular field, you are also able to demonstrate it. So try to spread your 4 internships in that manner, where you can strike a balance between the two, that you can also establish that you are interested in a particular area, in a particular field, as well as you are uh, also trying different things. Like I know Shreyas Sharma, he passed out in 2019, 18, sorry. So he joined me for a couple of months. He worked with me. So his internships were mostly in corporates. I mean, corporates in the sense he spread out his internships. He did in IP. He also did in litigation. He also did in an IP litigation firm, as also in Remfree Sagar, etc. So he was quite, I mean, he had different experiences. So I suggested him that, I mean, then according to his interest and I suggested his way forward. So that's what, if in litigation, see in IP litigation, if you have IP experience and IP corporate experience also, you might get into litigation. That's not a problem, because we have a specialization in that area. Our college is famous for that. So you will get opportunities in IP litigation firms, even if you have worked in TVS or any other, you have done internships in companies in Bangalore, etc. Yeah.
Sir,
And I
adding to
mean,
this,
and depending on, I'll provide my email to Parth and Utsav. So I mean, your individual queries also I can answer later. You can email it to me. So as depending on, we can have a personal chat and I can guide you regarding that. Yeah.
sir, adding to that, just I want to know if you take out the internship aspect of it. So how should at the college level, being in the college, uh, how to go about it? How to my interest lies in arbitration, because we can't directly go to case launch and read it. We won't be able to understand anything out of it.
Can you repeat your question? I mean,
Basically, he is saying, asking how to identify interest in particular area.
In being in college only,
Yeah.
not internship.
Without internship, how can we identify a particular area of interest? Because right now,
okay. Yeah, yeah.
we are in COVID situation, so our summer internship
Yes.
is washed out. So
Yes. Yes.
we might not be getting 2 months internship that we had got if there had not been lockdown. So how to
Yeah.
identify
Yeah.
a yeah
Yeah. Got it. Got it. I'll
yeah
just
yeah
tell you. So, uh, I'll tell you how I arrived at my interest of area, and that, I mean, that might provide you a certain clue as to how you can go about it. See, that's what I was telling you. In college, if you read as much statutes as possible in detail, like suppose in my interest in arbitration got invoked in a moot court experience, and in Subramaniam's class, we had an arbitration for moot for an arbitration case of Bhatia International and Balco. So Bhatia International case visa, and it is one of the landmark cases in arbitration field, the Bhatia International case. So what I did was I read the Bhatia International case, and then when I Googled it, and you Google it and you find out, you land up, you know that now Bhatia International has been overruled by Balco judgment. So then the Balco judgment was not the moot court case. Bhatia judgment was that. So to counter the Bhatia submissions, I completely read the Balco judgment. Balco judgment was 200-page judgment. And I prepared the Balco judgment so that I can incorporate those arguments in the Bhatia case that we are about to argue in the moot court. So that invoked extremely, when I read the Balco case, I got so much interested in arbitration, that because you will definitely know it. Once you read a particular law or a particular field, you will get interested in that and you will want to learn more about it. So I found the application of law as well as on facts extremely. I like confusing cases. I mean, the complex problems, the more the complex problem, I enjoy it. Yeah, I mean, reading complex problems and finding a particular answer, debating it with your classmates, which area generates that much interest in you, you will get to know by yourself. I mean, so that's why I suggest keep reading different statutes, follow different areas of law, insolvency law, keep your mind open. First of all, I would suggest as a law school student is that your mind should be open. You should not close your options very soon. There is a lot of time in the world. You can choose your area of interest. Just keep your mind open and try to read as much as possible in different areas of law, like suppose company law. Or and also I would like to tell you that I read arbitration in my second internship, and I did not read that subject in our semester. Prior to that only I read about arbitration, and I researched about it because I mean, in internships, they don't give you your work depending on your coursework. So I landed up doing arbitration research work and all prior to the me reading that subject in college. So that generated certain interest, and I read about it myself. And then when the subject came about in our semester, fourth semester, fifth semester, I don't remember correctly. So I was quite well prepared, and it generated more interest. So that's what keep your open mind, keep reading different statutes, and follow these portals and read insolvency law, bankruptcy law, data protection. See, about now, data protection is also one of this would be a booming practice in future, in next 5 to 10 years. So because of this COVID, there is a change in behavior. Now we are being forced to work from home. Most of the corporates are forced to work from home. The world has moved on from the physical world to the internet world. Now our transactions, our human to social interactions are more on internet rather than on physical world. So this would generate that much data, and it would be equally. This all social interactions in future would be governed by internet. So in that manner, in future, data protection will be a booming area. So keep your mind open. Read about data protection law. The bill is pending. It's not yet passed, but read about it. In Europe, GDPR is passed. It is a landmark legislation in Europe. Read about data protection. Read about AI. I mean, artificial intelligence would also be a booming area in future. Blockchain technologies, as well as everything. That's what I'm saying. You have the time, all the time in the world right now, to read about different areas and see what interests you more. I cannot tell you much more. I mean, because it's a very personal thing. Interest, you cannot tell what generates interest in you. So the only way you can find different your interest is by exploring, and by exploring means reading. So keep reading different areas and just see what interests you more, what creates a curiosity in you to read more, and which are without any obligation on you to read.
Yeah. Does
Yeah.
anybody want to ask question from attendees? Advait?
So I'd like to ask about the art of cross-examination that you had mentioned earlier, sir.
Hello.
So can you hear me, sir?
Yeah. Tell me.
So you'd spoken about the art of cross-examination at the beginning of your
Yes.
lecture, sir.
Yes.
How does one go about acquiring the skills of cross-examination, sir? Because oftentimes I keep hearing that unless you practice in a lower court, you cannot
Yes.
ever pick up the art of cross-examination. And people in the high courts nowadays lack the art of cross-examination, is what is being said all over the place. So
Yes.
how does one go about it, sir?
Yes. So basically, cross examination happens at trial work, original work. So like in arbitration is a original, like in an original jurisdiction or a trial court. You lay down the facts, you have to prove your facts. So cross examination is not much learned through reading than it is learned through practice. You cannot learn much by just reading, but nevertheless you have to read, and at least you should know the basics. I mean, see, P Ramanatha Iyer, I would suggest that book, you to read that book, and it contains lot of different scenarios and lot of different as to nature of the witness with whom you are cross examining. So that all, see, like he mentions about fear, of this kind of witness, that kind of witness, who is a witness who is overconfident. He has outlined different natures of the witness and how you put up questions to those kind of witnesses. That is what that book throws light upon. So, but in a practical scenario, it would be very different. I mean, that develops through practice only. Even, I mean, I'm young in the profession. I was lucky enough that, I mean, my cross examination went very well. The arbitrations which I have done, but it's basically. And then recently a lecture is given. I would suggest you to go to that lecture. Advocate Amit George had conducted a webinar on the art of cross examination, and he provided some basics. So you can go through that and then read about it. But you cannot pick it up. Surely you cannot pick it up only by reading. You would have to practice it, and that comes only when a real time problem comes before you. Yeah.
So I have one additional question. So can you give us the name of the book of James Fitzgerald?
Sorry.
The name of the books. James.
I'll text it to you. I'll text it to Parth. He might recommend. He might share it with you. The author name is James Stephen.
Okay, sir. Thank you so much, sir.
And the
So
book, that book you can find in archive.org for free. It's an ebook. You will find it.
Okay, sir.
Archive.org. You will get it.
Thank you.
So one of our students is asking in YouTube, sir, how does one get into criminal defense? And he's also asking, can a person doing defense work also easily diversify into other fields of litigation?
The second question I might be able to answer. The first one, I mean, I haven't practiced in criminal law. My practice has mostly been revolved in civil, commercial litigation and arbitrations. So, but definitely, see, it's basic law only. I mean, if you know the fundamentals of criminal law or civil law, the same principles apply everywhere. So it's easy to, in fact, that's what they say. The earlier lawyers, I mean, I would suggest 30, 40 years ago, they did not specialize in anything. They read CPC, CRPC, IPC, and Contract Act. They were equipped with the basic laws, but they easily migrate into other forms of other subjects and other forms of litigation because they know how to approach a subject. So it's easily to diversify your practice later, but initially, I mean, you should master the fundamentals. I'll give you an example of Abhishek Manu Singhvi, senior counsel. So we were briefing him in Monsanto case before the Supreme Court. So regarding the challenge to the validity of a patent. So in that case, Mr. Singhvi he did not know anything about Patent Act. Okay, nor about the technology of seed technology or the BT cotton or anything. But he knew all the basic principles. He's obviously he knows all the laws on his fingertips. So the moment we had to just explain it to him, what is the technology, how it is, and what is he knew about patent, what were the exceptions. And then he delivered it in such a manner that on the other day, when you listen to him in court, you will feel that he's a master of patent law and he has been reading this subject on seed technology since many years. So that's how it is. So diversification in other fields and litigation, it's not tough if you know the fundamentals. So regarding criminal law, I am not equipped to answer your questions because I don't know much about criminal defense. I haven't worked much in the criminal area.
So sometimes we see that senior advocates like Abhishek Manu Singhvi, P. Chidambaram, they are sometimes in corporate field, sometimes they even argue family matters. So
yes,
they can basically they can argue any matter. So is it possible for a young lawyer to specialize to develop that skill? Because now due to increasingly specialized world, we get advice from all the advocates that specialize in one field. So
yeah,
how
I
is that?
understood. See, this confusion always, I mean, will be there in your initial years, whether to specialize or generalize. I would suggest that have favorites in the subjects, but don't get pigeonholed in any one subject.
I mean, even I see, my core focus or my interest lies in arbitration, but I do insolvency matters. I do consumer matters before National Consumer Forum, as well as I do other matters, civil commercial matters. I do tender matters. I do writs before high courts. I do administrative law matters, challenging the administrative authorities. So basic litigation, you have to know. See, that's what I'm saying. Litigation, you cannot have your specialization. Litigation comes later. You have to have, basically, you should know the fundamentals of litigation, and you should know how to read a statute. If a problem comes, the facts are not, you won't get a facts uh, pertaining to only a particular law. The facts would touch upon various laws, and your mind should be open to look where to look and what to look for in the various laws. And nobody would tell you also in the facts. When a client comes to you and narrates you the facts of the case, initially, the the best thing the lawyer can do is know what all statutes apply to this case. That also you would have to do it in moot courts and all. That's what moot courts experiences are far away from the practical litigation world, because in moot courts you give a particular statute, more or less you know which statute would apply to particular these cases, etc., and you are given a particular proposition with particular issues, etc. Whereas in the real world, all these have to be framed from ground up. So that you can do only, that's what the estoppel example that I gave you. If you don't know what is estoppel, why will you apply estoppel in your case? Estoppel is in Evidence Act, but whereas in contractual transaction, most people, that's why don't use it, because they think that it is mostly used in promissory estoppel cases. There is a difference between promissory estoppel and estoppel. Estoppel it's a bigger set, and which promissory estoppel is a smaller set. So if you know about it, and how will you know about it? You have to spread yourself initially, read about everything that comes your way, and have a touch about a basic knowledge about all the statutes. And from that, you can slowly, you can have favorites subjects that you like to read much and you want to focus your area on much. But initially you have to take all your cases, especially if you are into independent litigation and independent practice. You have to take whatever work comes your way. Otherwise, it's difficult to sustain in the initial years. So specialization and generalization, what that issue is, it always confuses lawyers as to, now the seniors tell us that you should be specialized in one particular area, but whereas you should know everything.
Yeah.
So do specialize, but know about everything. That's the basic mantra.
Any other question?
Sir, are there any certificate or degree like patent agent which will help us in arbitration as such to attract clients if I'm going for a private practice?
Sorry, can you repeat your question? Hello?
Yeah.
Kishore, repeat your question.
No, is there any qualification that we can gain to attract specific clients of my field? Example,
No.
if I'm a patent agent, there'll be so people will
See,
recognize that okay, he's a patent.
That's what I told you. Marks or qualifications don't matter in real world. The only qualification that you require to practice is an LLB degree. Apart from that, initially for your CV and for LinkedIn profile and all, it's good that you have added certificates or diplomas from a particular institution regarding arbitration or patent or anything. It just shows that you are focused and you have a specialized interest in a particular field. But demonstrated experience that you are good in your subject. See, because the client comes to you with a problem, he is neck deep in a problem and he doesn't want to take risks. He cannot rely upon just your qualification to give you work. It has to be something else. That's why the only mode that is left to demonstrate your knowledge and your skill sets is writing. As much as you write and demonstrate your knowledge in various practical issues, you write on practical issues, people will come to you. They know, because these days everybody has a smartphone in their hands. People first make a Google search about whatever their problem they have, even non-lawyers.
and clients. So they should find your name in there. They should find your area. I mean, that area should be synonymous with your name, and then they will come to you. And then generally they ask their whoever, if they know any lawyer, they ask their lawyers, can you recommend me to somebody who knows arbitration law or patent law? And so visibility is the factor. So you should be known among lawyers, among non-lawyers, and that can be done only through writing in our profession. We cannot advertise. Qualifications, I don't think they matter much to the client, because the client in real world, marks, qualifications, these things don't add up.
Thank you, sir.
And as I told you, it's a service-based industry. The better the service you provide, the better people will come to you. And service is they will pay you only if you are useful, and degrees don't show that. So basically, I would suggest focus more time on learning the skills rather than gaining qualifications, different qualifications.
Any other question?
Yes,
Anybody?
sir. Thank you.
Shravan? So one of your intern is with us, Shravan. Shravan?
No more question.
Okay. Thank you, sir, for providing your time. It was very engaging session with you. We learned a lot.
Thank you. Thank you for having me. Sorry for the technical glitches and the trouble that I hope it was smooth for you. Thank you for having me.
Thank you.
I look forward to more such interactions with you. And I will provide my email ID. Anybody, if you
Yes, sir.
have any doubts or any guidance, if you need personally, you can contact me.
Okay, sir. Okay. Thank you, sir.
Thank you. Thank you for having me. Bye.